Last week, I put out part 1 of this series, and some of you actually live in this community, reached out, and you were right to. So before we go any further, I owe you a correction, so let's get into that.
I'm Cruzette Hydron. I've lived in Las Vegas for over 40 years. Welcome to my channel, where local insight meets real guidance.
I'm Cruzette. I live, work, and play right here in Lake Las Vegas, and I genuinely care about this community and the people in it, which is exactly why I'm not going to gloss over this. So in part 1, I covered the Webb Lake Las Vegas lawsuit against Pulte, the Nevada law behind it, and the court's arbitration ruling. And then I shared some additional information from community members about what's happening right now. Most of it checked out. A couple of things needed a second look. So let's start there. Today, we're doing 3 things. Let's correct a couple of things from the last video, give you some practical guidance if you're selling or buying in a community with litigation like this, and cover a new lending rule that's coming. I'll be upfront, this doesn't really connect to the Webb lawsuit. It's a separate rule about what lenders now have to review before approving a loan on a condo, including the HOA's finances and litigation history, and I'll get into it toward the end. Let's start with what's confirmed and accurate, because most of part 1 was. The Webb and Lake Las Vegas Community Association did sue Pulte. Attorney Norberto Cisneros does represent a group of individual homeowners in a related matter, and Judge Mark Denton did rule on May 13th that the case goes to arbitration instead of a jury trial. Now, there are 3 other attorneys handling separate cases. So those facts are confirmed and part of the public court record. The case number is A25-934238-B if you want to reference that for yourself. Here's what I forgot to mention in part 1. So in part 1, I referenced a specific dollar figure tied to a possible special assessment in this community, and that figure did not come from an HOA board vote, an official agenda item, or any confirmed board discussion. It came from a campaign material for a board election, specifically a re-election letter from a board member whose platform was that there would be no assessment if he was re-elected. That's a candidate making a campaign promise, not the board considering an action. So from what I understand, that candidate was not re-elected. I also shared some additional detail from community members, some resident stories, and some speculation about legal costs. Remember, these were just some things residents were saying, not actual verifiable information. One more thing before we move on. Whatever your role is in this, whether you're a homeowner living it day to day, a family that's been looking forward to a future here, or someone on the development and construction side working through the resolution, this has been a hard, stressful stretch for real people. I totally get it. I don't take that lightly, and I genuinely feel for everyone affected on every side of it. My hope is that this reaches a resolution that all parties involved can feel good about. A little more context while we're here. This isn't the first time Pulte or Webb has worked through construction defect litigation in this valley. Sun City McDonald Ranch, which is another Webb community, went through its own defect case back in the mid-2000s. I mentioned this in my March 25th video. Different specific issues which related to high-tech plumbing and stucco defects, not necessarily foundation and structural issues, but it's the same basic pattern. Problems were identified, the legal process ran its course, and repairs were made. And it's worth being clear on this too. From what's been reported, these kinds of structural issues don't affect every home in a community the same way. They're typically tied to a specific geotechnical conditions, soil and grading factors that can vary block to block, not something inherent to every property there. So let's talk about what's actually useful and provide you with some guidance. If you own a home in any community where the HOA has active disclosed litigation, Nevada law is clear under NRS 40.688. You're required to disclose that in writing to a buyer, typically at least 30 days before escrow closes. That's true regardless of whether your specific home has ever shown any damage, because the disclosure follows the HOA level dispute, not just individual homes. So in practice, that usually means 2 documents. The seller's real property disclosure form covers the property overall, and there's a separate construction defect disclosure and waiver specific to any construction defect claim tied to the home or the HOA. So as a seller, expect both in your file, but as a buyer, read them closely. The waiver is where you either cancel within your due diligence period or move forward and accept the disclosed defects. Buyers and their agents will typically review the HOA's resale documents, and it's reasonable to expect questions when there's no litigation. But how many homes are on the market, what they're selling for, comparable home values, that's a conversation to have with your own agent based on real current data. If you're selling into a community like this, the practical move is simple. Know your disclosure obligations cold and let your agent price based on verified current data, not headlines and not rumors. Now, if you're the one buying into a community with an HOA, any HOA, a few things are worth knowing that apply well beyond this one community. First, when you buy a resale home, you typically take on the HOA's existing cc&rs. If those cc&rs include a binding arbitration clause, which is standard in a lot of builder contracts, you inherit that clause too, even if you had nothing to do with the original dispute. Second, lenders take HOA litigation seriously. If an HOA has active resolved litigation over structural safety issues, that can factor into how easily a buyer gets approved. This is true broadly, not a comment on any specific loan or lender decision. Third, if a settlement or arbitration outcome doesn't fully cover repair costs, an HOA does have the option of levying a special assessment to cover the gap. That's simply how HOA finances work when a shortfall exists. And no matter what community you're looking at, here's a rule worth following. Never walk into a builder's sales office without your own agent. Builders disclose things like arbitration clauses, but it's buried in dense contract language. Your agent knows what that language looks like and can catch it for you. And at most sales offices, your agent needs to be registered with you on your very first visit to represent you at all. Okay, so here's the takeaway. Nevada law gives you real protections and real disclosure requirements, whether you're buying or selling into a community with an HOA. Those protections don't depend on any one number or any one rumor. They're built into how Chapter 40 and 40.688 work, regardless of what's circulating informally in any given community. If you're navigating a purchase or a sale in a community like this, the smartest move is leaning on an agent who verifies details directly with the HOA and any attorneys involved, rather than relying on a rumor or secondhand information. That's how you protect yourself and your investment. Okay, last topic, and I want to be upfront. This is separate market news, and it is not specific to Webb Lake Las Vegas. Starting with loan applications dated on or after August 3rd, Fannie Mae is eliminating what's called limited review for condominium projects. Condos specifically, not necessarily single-family homes with an HOA. So if you own or buying a condo anywhere in Henderson or Las Vegas, this is worth knowing. Every condo loan will now require what's called a full review, meaning the lender has to evaluate the condo association's budget, their reserve funding, insurance, delinquency rates, and any pending litigation before approving a loan in that building. Reserve studies for condo associations also need to fund at the highest recommended level going forward, and the required reserve allocation is set to rise from 10 to 15% of the annual assessment budget starting in January of 2027. So to be clear, this rule is about condominiums. Webb Lake Las Vegas is a single-family home community, and single-family HOAs are not subject to this full review requirement. I want to be precise about that. Nobody walks away thinking this connects to the lawsuit we've been discussing. It doesn't. So that's part 2. We've covered the correction, walked through what buyers and sellers should actually know, and got into the new Fannie Mae condo rule. So I hope that clears things up. If you've still got questions, reach out to me directly. Text or email is best. I'm hearing from a lot more of you lately, which I genuinely appreciate, so please give me at least 24 to 48 hours to get back to you. If you'd rather just talk it through, you can also book a free 15-minute consultation right on my website, your choice of a phone call or a Zoom call. All right, if this was useful to you, please hit subscribe. I put a new one of these every single week. And that is it for now. Thanks for watching. I'll see you on the next video.